I'm Caroline Bielanska and I'm Chief Executive of Solicitors for the Elderly. I'm going to spend a little bit of time talking about some recent cases that the Court of Protection have been hearing. The limited power to make gifts is set out in Section 12 of the MCA, so that attorneys under a lasting power can make gifts usually on customary occasions or to charities, provided those gifts are reasonable both into the circumstances but also in relation to the value of the donor's estate. If they attempt to extend the provisions of Section 12, perhaps by trying to define what is reasonable or trying to decide what should be tax planning gifts, then the OPG will refuse to register and make an application to the court for the severance of that provision. You can only make tax planning gifts by making an application to the Court of Protection, of course, when the donor lacks mental capacity, because otherwise he could make the gifts himself. There have also been a number of cases where the document has been drafted in an attempt to create a contingent attorneyship or replacement attorneyship, where the donee is under the age of 18. It's a specific requirement in the legislation that the donee is at least 18 years of age. So it's not like wills where you can appoint a minor but they won't be able to take out a grant of probate until they reach majority. With LPAs it's very restricted. The donor has to choose someone who is at least 18 at the date that he makes the appointment. It can't be contingent. We've also had a number of cases where the court have severed provisions relating to a condition where the attorney can only act when the donor lacks mental capacity, but the nature of those conditions is such that it would be rather difficult for the power to be used. In the good old days, with EPAs, would often put a clause in the power where the attorney would only be able to act when he had produced medical evidence to the Court of Protection, which was then, of course, the registering authority, that the donor is losing mental capacity or is becoming mentally unable to manage his property and financial affairs. Well, if we were to put that clause into the lasting power, it actually creates all sorts of problems, because capacity under the MCA is not all or nothing. It will depend on the decision that needs to be made, and it's not a continuing state. Incapacity is not a continuing state. Once you're deemed to be unable to make one decision, it does not follow that you're going to continue to be unable to make decisions indefinitely. So the court will sever those provisions.